I was just going to have us introduce ourselves. My name is Steph Bernal Martinez. I use she and her pronouns, and I do organizing and outreach at the ACLU of Alabama. I'm really excited to talk with y'all today about pretrial detention because I've spent the last few months collaborating with the good folks at the Montgomery Bail Out Fund and learning the ins and outs of pretrial detention and how we disrupt that system. So I'm going to pass it over to my homie and my colleague Dylan so he can introduce themselves, and then we'll pass it over to the bailout folks to introduce themselves as well.
Hi everyone, my name is Dylan Nettles. I'm policy analyst at the ACLU and I use he, him, his pronouns. Welcome back to the folks who have joined us for the previous sessions, and welcome to the new folks. We're really excited. I'll pass it along to our bailout friends.
Hello, I'm Charlotte Hireman. I use she and her pronouns. I'm a public defender at the Montgomery County Public Defender's Office here in Montgomery, and also help to get the bailout off the ground.
Hey everyone, my name is Ellen Degnan. I am an organizer with the Bailout and also an attorney in the Economic Justice Practice Group at the Southern Poverty Law Center. I'm really happy to be here, and my pronouns are she, her.
Hi y'all, I'm Ashley Edwards. In my day job, I am an investigator at the Federal Public Defender Office. I'm a social worker by trade, and I am an organizer with the Montgomery Bail Fund.
Thank you all so much. Jasmine, can you take us to our learning goals? Awesome. So I'm going to just touch on our learning goals for this session, starting with the first one. So we will understand how the pretrial detention process unfolds from arrest to possible trial. That's our first goal. Our second is we will explore how pretrial detention disproportionately impacts Black, Latino, and working class communities. And our final is that we will learn how to disrupt the practice of pretrial detention. I also want to just point out that I'm sure you all will have questions as we go along. Please feel free to use the Q&A option down at the bottom of your screen. Leave your questions there. We will try to make as much time as we possibly can towards the end to circle back and have our experts address your questions. Steph?
All right, thanks, Dylan. So the nature of this webinar, because of what we're talking about, it also requires a content warning. We'll be talking about some pretty heavy issues that more acutely impact Black and working class people. And we'll also be talking specifically about police and prosecutorial violence. And also we'll be talking about suicide. So just for folks to be able to take care of themselves and do what is best for them as we move along through this content. All right, next slide. Okay, so real quickly, this is not obviously the most expansive version of definition of pretrial detention, but for the sake of this webinar, when we're talking about pretrial detention, we're talking about the experience of someone who's arrested and then held in jail before trial and has not yet been convicted of a crime. So we'll be working with that definition as we move forward. So one example that I'll talk about throughout this webinar is, so this example of like someone who's accused of stealing a backpack is arrested by police and then taken to the jail. They may not have been convicted of that crime, but they're arrested for it, right? And they can remain in the jail until their trial. So the case that we'll be talking about, and Jasmine, I think you can actually move to the next slide. The case that we'll be talking about a lot is Khalif Browder's, based out of New York City. He's from the Bronx. And so I'm going to set us up by reading just a short vignette from a piece from the New Yorker about his story. So in 2010, 10 days before his 17th birthday, Khalif Browder and a friend were returning home from a party in the Bronx. As they passed East 188th Street, 8th Street, Browder saw a police car driving toward them, and more squad cars arrived, and soon Browder and his friend found themselves straight on with the police. An officer said that a man had just reported that they had robbed him. Browder replied immediately, "I didn't rob anybody, you can check my pockets." The officers searched him and his friend, but they didn't find anything. And as Browder recalls, one of the officers walked back to his car where the alleged victim was and returned with a news story. The man said that they had robbed him, not that night, but 2 weeks earlier. Still, the police handcuffed the teenagers and pressed them into the squad car. So from there, they're arrested. At the 48th precinct, the pair was then fingerprinted and locked in a holding cell. A few hours later, when an officer opened the door, the teens were then taken to central booking at the Bronx County Criminal Court. So late on Saturday, this is already 17 hours after they've been arrested, an officer and a prosecutor interrogate him, and he maintains his innocence. The next day, he's led into a courtroom. There, he learns that he's been charged with robbery, grand larceny, and assault. The judge ordered him to be held, and his bail was set at $3,000. So the amount that his bail was set at was completely out of reach for his family. And so therefore, Khalif Browder found himself at Rikers Island, a jail in New York City.
So Steph just touched on, of course, the story of Khalif Browder, which we will return to a little bit later in this webinar, but I want to talk to you about the process that leads someone to being detained pre-trial. And so I'm just going to give you, again, a very high level, kind of more surface level, I should say, view of it all. I think you all probably realize the complexities of the big criminal punishment system are just that complex. But this just gives you a little overview. So the first thing that occurs, of course, is that a person gets arrested. The second is that an officer and a magistrate figure an officer and a magistrate figure out an initial charge or a basis for holding that person who was arrested. Next, that person gets to see a judge, and the judge shares the charges and determines if they will be released, detained further, or if they will be detained with or without bail. So a couple things can happen actually at this point. If the judge releases you on your own recognizance, you are free to go until your next court appearance. If the judge detains you with bail, the judge will determine your bail amount and reprimand you back into the jail. If you can't afford to pay your bail, you will be released. If you can afford to pay your bail, you will be released and you'll have to return for your next court date. If you can't afford your bail, then you can possibly go through a bail bondsman to front the cost, or you must wait until your trial or your next court date. We, of course, mentioned judges have a lot of discretion here. So really the final piece to this is that if the judge detains you without bail, you can be held until your trial with no chance of getting out.
Thank you, Dylan. So, and I also just want to honor that I've learned a lot about this through the folks who are panelists here today. And so I just want to honor and recognize that, because the system is, I think, intentionally confusing and convoluted so that we are unable to advocate for our people. And it's because of the panelists that we have on here today that I'm beginning to get an understanding. So I'm sharing some of the knowledge that they've explained to me and taught me. So going back to this, we talked about this huge amount of broad discretion that judges have in making these determinations. So there are laws that govern what should happen after you're charged with a crime, and Dylan named the 3 things that a judge can essentially decide for you, right? And so the way the rules are written allows judges and prosecutors this broad discretion to interpret and to apply these laws how they see fit. So according to the laws that govern and determine what should happen when someone's charged with the crime, a person should really only be held before their trial if they're a flight risk or if they're a danger to their community, right? But those things can be quite vague or can be left to interpretation. So most people could be released on their own recognizance because they're not a flight risk, or they're not a danger to their community. And all of these laws are outlined actually in the Alabama Rules of Criminal Procedure. So this is like, yeah, this is how it's set up. But because the judges and the prosecutors have this discretion that we're talking about, many people are actually held with or without bond. So those two considerations we just named, like whether you're a flight risk or whether you're a danger to your community, they're written in such a way that gives judges and prosecutors so much power, and they can determine the outcomes and conditions of release for this individual who was arrested and charged, right? So I talked about, I brought up Khalif Browder's case, which we're actually going to move into now and return to see how that played out for him, this judicial and prosecutorial discretion. Jasmine, if you'll jump to the next slide. All right, so I'm going to return to this narrative from the New Yorker that has been telling Khalif Browder's story. So it goes, Browder had already had a few run-ins with the police, including an incident 8 months earlier when an officer reported seeing him take a delivery truck for a joyride. Browder was charged with grand larceny then. He said that his friends were the one who drove the truck, but he had only watched, but nonetheless, he pleaded guilty because he felt like he had no defense. The judge at the time gave him probation and a, quote, youthful offender status, which meant that he wouldn't necessarily have a criminal record. On the morning of July 28th, going back to when he was picked up for the backpack, Browder was awakened at around 4:30. He was handcuffed to another inmate and herded out onto a bus with a group of other prisoners. At the Bronx County Hall of Justice, they spent the whole day in the basement holding pen, each of them waiting for their chance to see a judge. When Browder's turn came, an officer led him into the courtroom. He caught a short glimpse of his mother in the spectator area. And at that point, 74 days had already passed since his arrest. So again, he had not been convicted of anything. He was still just with charges. He had already missed his 17th birthday and the end of his sophomore year and half of the summer. So a grand jury voted to indict Browder. The criminal complaint alleged that him and his friend had robbed this person, and he was also accused of punching this person. A clerk read out the charges, robbery in the second degree and other crimes, and Browder still maintained his innocence and pled not guilty. So because he was still being held without bail, he was escorted out of the courtroom and back to Rikers.
Thanks for that, Steph. Jasmine, let's go into the next one. So we're gonna just go over a few quick facts that really underscore why the broad discretionary power that the judiciary and prosecutors hold really matters. And you can see the first one here, which is that two-thirds of people in the US jails are there for pretrial detention, and many of those people will be found not guilty and have their charges dismissed. Next slide. Many people are held longer than what they would potentially be held even if they were convicted of the crime they were arrested and charged for. Next slide. And pretrial detention pressures people to admit guilt, to simply get out of this very convoluted mess that Steph has expressed through the story of Khalif and the other information you've gathered so far.
So the reality is that pretrial detention has these really big unforeseen, and I put unforeseen with like a little, you should hear that with an asterisk, because it's also fair to say that the system was built this way, so it actually is not that unforeseen. But the reality is that it has these unforeseen consequences, and Dylan talked about the conditions of jail pushing people into pleading guilty to charges they might have not even committed. When you can't afford your bail, there's no end in sight. It's clear that pretrial detention is a coercive mechanism for the state to secure these convictions, right, and incarcerate predominantly Black, Indigenous, and people of color and working class people. Also, pretrial detention actually has this hugely negative outcome for the individual and the community. So even if we look beyond the person, it will have a ripple effect for the community. The data has shown us that the longer someone is inside, held pretrial, it'll negatively impact their post-release actions. So we're going to watch a short video before we talk to our panelists for a minute, but we'll watch a short video that outlines how this functions.
Here's the problem with our cash bail system. The idea is that if you have money, you can buy your freedom, and if you don't, you can't, and you sit in jail. 2/3 of people who go to jail in this country live below the poverty line. Incarceration only perpetuates that inequity. The easiest way to think about the cash bail system is that it's criminalizing poverty. So here's how bail works. When somebody gets arrested, they're accused of a crime, and that's all it is. It's an accusation. And then they go in front of a judge, and a judge, oftentimes in this country, sets bail. Doesn't matter how serious or how petty the offense is. In fact, the vast majority of people who are sitting in jail in our country are there on low-level crimes, on low-level offenses. Nothing that makes us worry about public safety. When bail gets set, if that person has $500, $1,000, $5,000 to pay that bail, they get to go home. They get to go back to their jobs, to their families, to their communities. They get to fight their case. They get to fully enjoy that presumption of innocence. But if they don't have $500, $1,000, $5,000, they sit in jail. And what we know is when somebody is sitting in jail, they're more likely to plead guilty just to get out. They're more likely to also suffer the impacts of being incarcerated. So we know in this country that who money bail impacts the most are communities of color, Black and brown people, people who don't have access to money, who don't have access to wealth. The problem with bail is that it's not just about not having that money and you sit in jail, but there are all of these other collateral consequences. And what I mean by that is all of the other ways in which somebody's life is impacted simply for not having, say, $500 to pay their way out of jail. That might be that you lose your job. It might be that your kids are taken away from you because there's nobody else to take care of them. It might mean that you fall behind on your rent and you can't afford your apartment or your home, and then suddenly when you come out of jail, you're homeless. There are so many other impacts like that that the cash bail system has, that it's not simply about money in your criminal case, but it's really about a person's life. The mass incarceration in America is 2.2 million people in jails and prisons. And what doesn't get noticed nearly enough is jail is the front door to incarceration. In this country, there are 11 million admissions to jail every year. And in the past 3 decades, the majority of the increase in incarceration is because of bail and pretrial detention, meaning bail is set, people can't afford it, and there are more and more people in our jails every single day, more and more people contributing to that 2.2 million of mass incarceration in this country because of bail. Sitting in jail destabilizes a person to the point that even when they get out, they're more likely to be rearrested, more likely to have continued contact with the criminal justice system because that period of being in jail, because they couldn't afford bail, leads to what's known in the business as a criminogenic effect, meaning once you are in the system, you're more likely to be in the system again and again. And that is ultimately because the person was too poor to make bail the first time around. Everything that sets them up to be safe, to be law-abiding, to be healthy, and to be well falls apart. And that is what the criminalization of poverty is.
Okay, so that video really segues us right into our next section, which really just deals with the consequences of pretrial detention. And you just heard in the video about some of those collateral consequences. And the truth is that collateral consequences more acutely impact Black and Indigenous people of color because of the racism and classism baked into our laws. Monetary bail is typically assigned without any assessment of a person's ability to pay. And of course, because of systemic racial and economic inequities that already exist in this country, that makes it more likely that Black and Indigenous people of color will be most impacted. Researchers have noted how the nature of court hearings at which various pretrial decisions are made, such as whether to grant release on bail or the amount set, creates an opportunity for judges, knowingly or not, to be influenced by racial stereotypes. Returning to the story of Khalif, as Steph pointed out earlier, he remained jailed because he couldn't afford to pay $3,000 in 2010. But violence and long stints in solitary define Browder's experience at Rikers, as detailed in the New Yorker profile from 2014 that Steph has been talking about. He actually told the New Yorker, "I'm not all right, I'm messed up," after his release. And the story sparked outrage and promises from city officials to reform Rikers, but for Browder, the damage had been done. And he did unfortunately die by suicide on June 6th of 2015. He was 22 years old. I also want to move on and touch just a bit on the impact that also the pretrial system has on women, particularly women of color. One of the initiatives that you all may have heard about in recent years is the Black Mamas Bailout, which is led by Southerners on New Ground. It's coordinated for Mother's Day and is a bailout that is handled by Song across the South in order to call attention both to the importance and centrality of Black women, Black mothers, and Black caregivers to our communities, as well as the particular impact that mass incarceration is having on Black women. Reports have shown that monetary bail disparately impacts women, and although judicial officers release women on recognizance at higher rates, denies them release less often, and sets lower bail amounts for them, women are less likely to be able to afford bail when it is set. Women are also more likely than men to have lacked employment prior to arrest and generally earn less than men when employed. It's often women, however, who absorb the financial costs, including bail, attorney's fees, and court fines and fees when family members are incarcerated, which in many cases deepens their financial insecurity. Passing back to you, Steph.
Thanks, Dylan. I think we have the same struggle that we had last time in our last webinar with video, with letting our panelists come on video. So I'm just gonna set us up for this next part of our webinar, and then I'll try to do some tech in the background. But we're actually gonna shift into talking to Charlotte, Ash, and Ellen so that they can talk through and help us scheme a little bit about disrupting the pretrial system, right? So we shared a lot of really tragic and really heavy and discouraging information about the way that it currently works, but there are ways that folks who are organizing or who are attorneys who are doing particular types of work to disrupt the system. So I'm actually gonna start with Charlotte. Charlotte has taught me a lot about the importance of a meaningful and speedy trial. And so I wanted to give her an opportunity to talk about how that particular right that we are often taught about in school, right? If you think about public school, like that's one of the rights we're taught about. If she could talk a little bit about how significant that is and what we need to do. So I'm gonna pass it to you, Charlotte. I'm sorry we don't have video.
Thank you, no, it's fine. So as Steph was saying, the right to a speedy trial is codified in the United States Constitution in the Sixth Amendment. It is something that is intended to be afforded to every person accused of a crime in the country. But how that is realized in practice doesn't actually often look so speedy. So in Alabama specifically, when someone is initially arrested, they are arrested based on a police affidavit. And that affidavit is sworn out by a police officer and then is tested in the district court in what's called a preliminary hearing. During that hearing, the judge is simply trying to determine whether or not a crime probably happened, and if the person who is currently in jail for that crime is probably the person who committed it. Any type of evidence is admissible. There's no need to subpoena witnesses other than the officer who is investigating the case. And then the case, if the judge finds that there's sufficient evidence presented by the police, then a person sits in jail waiting for indictment. That can take, in Montgomery County, more than a year. So often clients of mine are not actually even sitting in jail waiting for their day in court. They're waiting to find out if a grand jury is going to file charges against them. So that is a huge moment in time where people spend months and months in jail that could be avoided if Montgomery County imposed a stricter indictment schedule, or if that was codified by statute as it is, or written down in statute as it is in other states in the country. The other issue is that even once someone does have charges filed against them, the clock to get that case to trial doesn't actually mean anything. It's as though it doesn't have numbers on it. In other states, I mean, Kalief Browder is a terrible example and reflection of the injustice that still happens in states that do have meaningful speedy trial laws. But in New York, at least, there's a requirement that all misdemeanors go to trial within 90 days and all felonies go to trial within 180 days. In Alabama, the case law that defense attorneys use contemplate like whether or not enough time has run when someone has been awaiting for trial for 18 months. That could be remedied if the legislature would draft and pass a meaningful speedy trial law. That could also be resolved by court practice within individual jurisdictions. But it is something that impacts every person who is held in jail pre-trial in Alabama, that there's no meaningful way to impose an expectation of speedy prosecution in their case. If anyone has any questions, or can keep.
Thank you, Charlotte. Again, if y'all have specific questions, please put them in the Q&A or in the chat, and we'll have time at the end to answer questions for folks. The other piece of this, Charlotte, and anyone else can jump in too, if you talked about the demand for a speedy trial, and I wonder from the advocacy standpoint, so folks who are lay people like myself, or people who organize, or people who are in the community who want to support folks, are there ways specifically around the speedy trial piece that we as commoners, if you will, can advocate for this? Like, what would you suggest?
Definitely. I think that asking your elected district attorneys and elected judges what they insist on and what their expectations are around clients, or as they would call them, defendants' speedy trial rights is meaningful. I also think that advocating with the legislature to codify that right and get it established in statute is something that we really push for. At the same time, even where there are states that do have meaningful more meaningful speedy trial laws, time somehow takes on this really amorphous and non-literal way of being when calculating what those days are and what makes up the countdown for a speedy trial. So also that's why it doubles back really to the practice of individual prosecutors' offices and individual judges.
Thank you. I appreciate that. We do have a specific question. I'm going to just pause it for a second, table it for a second to move through these other pieces, but I do want to come back to it. I want to invite other folks who are on the panel. If you could talk a little bit about the ways that we, beyond the speedy trial, how we could support folks who are being held in pretrial or who are released. And so if anyone wants to share about like those types of supports for people, so we are setting them up for success so they're not trapped or they're not experiencing the kinds of consequences, collateral consequences that we learned about with Khalif Browder's story. And feel free, anyone, to jump in on that one.
Well, this is Ellen. Yeah, that's a good question because I mean, I'm coming at this from a bail fund perspective, though I am by no means an expert. We're just starting, really. I think something we struggle with is how, as a collective of people, like we can, I don't know, we can help people who were inside and are, you know, have been bailed out to make the connections that will help them find a little more stability than they would have otherwise. That can mean helping them find a halfway house to live in and paying their rent for a time. It can mean connecting them to, you know, in Montgomery at least, like the few but mighty resources that are here, like the Dannon Project, where, I mean, it's incredible. People, I think between the ages of 18 and 25, are paid to study, are paid to work towards their GED, are, you know, taken to get licensed in various trades so that they can you know, get a longer term stable job. Other ways we support them, you know, giving them food when they are hungry, and sometimes they are, right? But that means, like, it's not just a giving, it's not just, like, it's really important, at least for me, and I think for us, to not think of the support as charity, but rather like only possible when you have a respectful relationship with like another human being, where like they want to share their time with you and you want to share their time with them. And like it's reciprocal and voluntary in that sense. And like from that, you know, all else follows, including, yeah, like the various kinds of support that I just shared, always with the recognition that like we cannot create the systems that are missing. This is something that I'm learning from my fellow organizers and friends. We're not going to be able to overnight create a functioning mental health system in Montgomery. And so, you know, you do the best you can, you problem solve with what you have, but like, you know, it's like we owe this to our, like, you know, we owe this to our people. And so, yeah, I don't know if that answered your question, but those are some of my thoughts.
Thank you, Ellen. If other folks want to share too, feel free to jump in. I remember one example that Charlotte had shared with me is if someone is released and then they are expected to return to court, we don't really provide any ways or supports for folks to be able to do that. So even the very act of being able to return to court is a major challenge for people, whether they don't have transportation or they don't have a way of tracking or remembering when they need to return. So like one tangible example that Charlotte gave once was our court systems being able to have text alerts, reminders, something really simple that can mean a lot for people. And again, those are like reform, just like sort of playing within the system kind of suggestions, but they do have an impact, a material impact for people. Thank you. I'm sharing that because that was something specific Charlotte has shared. Also, so because I wanted to time check, and we're sort of like have about 15 minutes left, and I want to talk about the bailout, specifically the Montgomery bailout work that y'all, all three of you have organized and led in. And there's so much that goes under the work of the bailout, but if y'all could talk specifically about, Ellen often describes bailout work as being like more than just bailing people out individually, but as an opportunity to like recognize people's freedom, recognize people whose freedom can be attained, and then so much more than that. And so if y'all can talk a little bit about the role of the bailout in disrupting this pretrial detention, both as like bailing out individuals, but beyond that as well. And anyone can jump in, please.
I would jump in, but like I just spoke, so I would also love to step back and follow.
I think that one of the things that we talk about a lot as a group is that the cash bail system need not exist. Like, it doesn't serve an actual meaningful purpose, and in that way it's predatory. There are people who are making money off of the industry of cash bail. The courts, the judiciary is making money. The jails are making money. The bail bonds people are making money. And I think that through the practice of bailing individual people out, we are hoping that little by little, we are sort of diminishing the power of the predation of cash bail to an eventual end where cash bail would not be necessary because or like bail bonds people would not be necessary because we've just paid everyone's bail and are not expecting anything in return. So I think the cyclical nature of what we do, when we post someone's cash bail, that money will eventually come back to us when they reappear in court. We are sort of creating an ecosystem in which the people who are incarcerated owe us nothing. And like Ellen said, we are creating more meaningful relationships that aren't sort of transactionary. And by that way, we are working to dismantle cash bail and working to build community, which I have found really meaningful.
I want to retweet everything Ashley just said and let's see, add a couple ideas. One of which is that I am challenging myself to view or to reflect on how bailing out a single person, it's not dismantling the pretrial detention system, but I do think even that single act is disrupting the pretrial detention system in that, like, I do think everything comes back to relationships, like all good organizing as well, right? It's all in relationships. And so like we are forming connections. We are connecting across, a boundary that the state, has topped with barbed wire, a boundary that reflects like exclusion, right? A boundary that seeks to isolate are people, like from their people, from their homes, from their communities. And so I think that when we like reach across and connect, like we are transgressing. And I know it's a little idealistic or maybe abstract, but I guess it's important for me to ground myself in that, because I think that like our systemic analyses, right? Like everything Ashley just said, how, you know, we are interrupting like the cyclical, or rather, I think we ultimately would like to displace cash bail, displace the industries that kind of survive, right, and thrive off of cash bail. That's in the long term, but like even in the short term, every act is kind of like a rebellion, and so that means that it's like all the minutia that matters. Like when you show up to post cash bail and you realize that they don't know what to do with cash bail, they don't know how to process the cash because no one posts cash bail. It's only bond companies that operate in this space. So it takes hours, no one knows what they're doing. Months later, still no one knows what they're doing. Like what you're doing there, like what is disrupting there? Disrupting is showing up in a place where you're not expected. It's confusing people. It's observing, you know, it's observing what other people have ignored or overlooked. It's like asking questions that they wouldn't have thought of. And so like, I think all of this is disruption, and like all of that is achieved right in the very act of, you know, helping someone attain at least their bodily freedom. And yeah, so I'm trying to think if there are any other like simple examples. Yeah, and I guess just also going back to relationships, like the conversations that you have, the consciousness raising that like every conversation has the potential to achieve. So like when you are staying overnight, you know, awaiting someone's release that you've posted bond for, which a couple folks did earlier in the summer after some protests, and there's a jail guard there, and you strike up a conversation, like that is an opportunity to you know, say what you believe, right? But also like ask questions and understand where this person is coming from, because we need to do that too. Not because we intend to move right to their position, but because because like they're all part of the system and they're embedded in it. And I don't know, I think it's our duty to I guess challenge them to view things differently as well. Sorry, I talked so long. I'll stop.
Ellen, I want to jump in here actually, because I mean, those are really great points. And I'm so glad you talked about like the disruptive work of bailout organizing. And one of the examples I was actually thinking about as you were like listing some of those as well was even when we had the opportunity to speak with a judge, when we had a person who we were working to bail out, and that individual had an upcoming bail hearing, which Ellen and I zoomed into right from, well, at least where I'm at right now. I don't know about Ellen, but, and we just talked about the bailout. Of course, we, other than the kind of information presented to us, didn't know a ton about this individual in particular, but he was on our radar, and in advocating for his bail reduction, we were able to inform that judge more about the bailout and like what are the positive impacts of bailouts. Does the data support about people returning to court if they have been bailed out by a bail fund? And so we saw in that situation a judge that learned about the bailout, ultimately felt comfortable in reducing that individual's bail and allowing them to be able to go to stay with a relative into their court date. Whereas in another situation, they may have, even if they were released, they may not have been released with a reduced bail, and they may not have been allowed to go out of state to stay with that relative. And so I just think about how powerful that is if we are able to have so many more of those conversations and just be persuasive to these judges that are, as Steph touched on earlier, who have an incredible amount of discretionary power, but it's, as Ellen and so many others also pointed out, really ultimately are going to be the decision maker, of course, at the end of the day about like this person's freedom, and are entrenched in the system though, which, as we've all talked about, really is not conducive to people really getting free. Even if they are, we've seen now the incredible collateral consequences that even can come from a short stint in jail. So I really appreciate those points, Ellen. I just wanted to add that.
Thanks, y'all.
Yeah, but
Sorry, go ahead, Charlotte.
thanks. What this made me think of, and also in connection to all of these things, and also Erica, your question on the Q&A about public health. I think that so often judges and prosecutors, and also, you know, other court people in the court system think very particularly about what public health and what public safety look like. And they think about it as the potential harm that the person before them in an orange jumpsuit could cause. And they are very reticent or just unable to think about the harm that's caused by that person's absence. I think that one great thing that bailout work does is to bring in, to make it known that there's a group of people who are thinking about public health and public safety in a way that puts the real consequences of incarceration at the forefront, and makes it known that that's something that individuals in our community want to prevent and want to help alleviate. So I think that is something that, Erica, to your question, judges, there has been some thought about what coronavirus in the jail looks like, and how that could lead to people being released from the jail, or to the length of their sentence. But I think so often they're much more concerned with what, whether or not their very narrow definition of public health and public safety is going to be like violated or disturbed if someone is released, really by a hypothetical. But that's the metric that we have, as a community, have asked our prosecutors and our judges to make decisions on for a very long time. And the bailout makes it possible to present a different model.
Yeah, and I'll add a little there, Charlotte, as far as Erica's question as well. And like one of the things we did early on with the bailout too was really emphasize in our messaging that that these individuals who are being held pretrial are members of our community. These are our neighbors. These are people's family members, and they are being affected. They're actually being put at grave risk by being held pretrial in facilities in which social distancing is not even possible. And so we know that those individuals, if they are eventually released, will come back home or come back into the community where there's a potential risk that they could further spread the virus. We also know that people, though, they are coming in where they could be potentially bringing the virus in, and then we have staff that work in those facilities that come back out into the communities. And so it really is exasperating what we already know is a public health crisis, and it really is not it's not really a solution forward way of combating that. But it's also what we try to, I think, really underscore is that it's also a really bad way to also actually address our community concern for what this virus is doing to people around us.
We have a couple of more minutes before we have to close, but I wanted to make sure that I did not drop, I believe it was James's question, but there was a quick question, if we can answer it, Charlotte or anyone else on the panel, about how long a person can sit in pretrial detention in Alabama. If you have a quick answer for that.
Definitely. So the answer is there is no limit. I'm sorry, I used 18 months as an example. That's a holding from one case where a court said that someone being held for 18 months violated their speedy trial right. But there really is, there's nothing set in stone, nothing established that places an actual limit.
Thank you, Charlotte. I really appreciate that. I want to give y'all a chance to just maybe share your own call to action as it relates to the bailout. I know that the Montgomery Bail Out is going to have a training, but I do want to give whoever a chance to share and invite people to join in that work. I will also name that there are bailout funds popping up all across the state. For sure in Tuscaloosa, there is a formal bailout fund. In Hoover, there is also one, and that one seems to be a little bit scrappier in terms of like who manages it. So there'll be a couple of contacts that I'll share out with y'all if you're trying to organize with the Hoover bailout. And in general, I'm just inviting folks to get involved with their bailout fund because there's so much work to be done. I'm gonna also note the other resource that I'll share out. Charlotte has taught me a lot about risk assessment tools, and those are critical to all of the things that y'all have named already in this webinar. So Erica brought up like thinking about the health risks. And so that's another piece that we want to learn more about, which we didn't get time to dive into today, but I'll share some resources on risk assessment tools, which are often referred to as RATs, because you mean they're trash. But I'm going to pass it in our last minute over to bailout people to please invite us into this work.
I can start, and I think this is more broad than the bailout specifically, but once we are back in person in court, I would invite you all to come to court. So much of this happens beneath a veil of darkness, and I think making people aware that the community is watching and is curious and interested is definitely one step that you can take, and it is also incredibly edifying and fascinating.
Yeah, I would invite all of you, first of all, like, thank you again for, I guess, having us, and Charlotte and Ash and of course, Steph and Dylan. It's been lovely talking with y'all. And we're having a training for the bailout on September 14th. Do I have that date right, Steph?
That's correct.
Yes.
Yes, okay, September 14th. A link will go out. Please, please, please come if you can. It's gonna be 2 hours so that we have time to get into the nuts and bolts of the various ways you can plug in, whether that is doing the actual posting of bail, which, fun fact, attorneys can't do in Alabama. So, you know, just keep that in mind. Or the like forming relationships with people once they are released. So we refer to them and ourselves, I guess, as bail buddies. And that involves checking in, you know, trying to serving as a resource for them as they wish, right? If they don't want to have a relationship, there's, you know, of course we wouldn't force that upon them. Other things you can do, you know, be a part of the really kind of weighty decision-making process of how we spend our time and the money that like community has, and not just community, but like across the nation, people have entrusted to us. You know, so yeah, please come to that September 14th training. And I guess Dylan just put the link in the chat.
Thank you so much. Ash, did you want to add anything? No pressure.
No, everyone has covered it. I'm just so thrilled that this work is happening and happening so very quickly. You know, it's hard sometimes to see, I think, the silver lining of the pandemic. But for me, this bail fund and the bail funds that are popping up across the state are truly, truly a silver lining, because they will far outlast this pandemic, and there's lots of work to be done.
Thank you. And thanks, y'all. Again, sign up for that training with the Montgomery Bail Out Fund at bit.ly/skill up get free. It's in the chat. I will also send a delightful email with so many resources and links that you won't even know what to do with. But again, thank you all for being here. Thank you to all of the panelists, and thanks to Dylan. And I will see y'all in email. Bye.